reading between the lines, courts and constitutions. Nobody would claim that their own thinking was ideological, just as nobody would habitually refer to themselves as fatso. Ideology like halitosis is in this sense what the other person has. Terry Eagleton. Constitutions are considered the foundation on which law and politics are built. Whether made up of formal documents or formalized customs, they are supposed to contain the terms and conditions on which political power is to be obtained, allocated, exercised, and controlled in a legal manner. They are meant to be an institutional and constant matrix within which the ebb and flow of political action occurs. Indeed, great stock is set by the extent to which states subscribe to such constitutional promise and strive to achieve such constitutional practice. Those that function in line with such an aspiration are respected as being largely democratic and just. Those that do not are dismissed as despotic and inequitable. Accordingly, the claim that constitutions can operate as an institutional constant has very important implications for both the theory and practice of democratic law and politics. If the claim can be defended and validated, much progress will have been made in promoting the virtue of such constitutional democracies. Those countries that subscribe to constitutional government will be vindicated as being both politically legitimate and legally sound. If not, then the validity of such regimes will be suspect. Those same states may then be seen as no more legitimate or lawful than those tyrannical regimes that openly flaunt such ambitions. In short, without some defensible notion of a stable and predictable constitution, constitutional democracies will be obliged to defend their democratic legitimacy as much by reference to their substantive fairness as to the formal accoutrements of constitutionalism. This is no bad thing. Good governance ought to be as much about the what is decided as how it is decided. However, the idea and practice of government based on a stable and constant constitution proves more illusory than real. The belief that constitutions can ground anything is a dangerous conceit. Instead, in line with the critical approach that I have been developing, I insist that constitutional law operates in much the same way as the common law generally. There are two principal differences. First, the stakes are usually higher in constitutional law in that, unlike with common law decisions, the courts are striking down legislation and their decisions cannot be easily countermanded by the legislature. Second, when dealing with constitutional matters, courts have to respect in some way the formal and written documents that form the basis for both their striking down power and the circumstances in which such power can be exercised. However, while these differences ought not to be trivialized, it is reasonable to assume that their effects do not unduly affect the character of adjudication. In the same way that common law judges are not entirely free to do whatever they choose, that is, they recognize a felt obligation to situate their decisions within the body of existing legal doctrine, so constitutional judges are not entirely restricted in their ability to act in a way that best effects justice. That is, they note that formal written texts do not give the kind of specific guidance that can mechanically resolve concrete disputes. In this way, judges work the considerable space between choice and constraint and, in the process, are both free and restricted in their fulfillment of their institutional responsibility. Indeed, it would be odd if the difference between the style of constitutional and common law adjudication was substantial or striking, as it is exactly the same judges who engage in both. The difference is more a matter of emphasis and degree than difference in kind. Judges bring to each task a shared sense of both the similar challenge, acting in a way that does not entirely collapse the distinction between constrained legal analysis and open-ended ideological decision-making, and the appropriate method for meeting it, utilizing the past to resolve present problems in a way that helps to clarify the future. Constitutional adjudication, therefore, is simply a particular kind of common law adjudication. The basic components of the common law mindset are adapted to the specialized demands of the constitutional context. In this chapter, therefore, I contend that constitutional law is an organic work in progress whose lifeblood is the continuity of change. Any distinction between its formal and informal revision or between its fixed and fluid dimensions is mistaken. There is a constitutional tradition of political transformation in which there is development and growth, but not always in gradual ways or progressive directions. In the first part of the chapter, I look at the grand historical sweep of Canadian constitutional law and explain how its contours have often been shaped in unexpected ways, with unpredictable results, and by powerful political forces. In the next three sections, I grapple with the jurisprudential debate on legal hermeneutics that has been played out through the recent American Supreme Court physician-assisted suicide decision in Glucksburg. Concentrating on the pivotal judgment of Justice Souter, I first situate the case and its judgments in their jurisprudential context, then unpack some of the hermeneutical claims of Souter's judgment, and lastly explore the political implications of this style of judicial decision-making. In the final section, I return to the Canadian scene and offer a reading of the Supreme Court of Canada's decision in Re Quebec Reference that illustrates the kind of legal reasoning that my critical approach recommends. Throughout the chapter, I advance the critical theme that what canons does distinguish one political system from another is the political substance of their governmental practices, not the formal legitimacy of their legal procedures. This, of course, is simply another way of driving home the critical message that law is politics. There is no escape from politics and, as importantly, nothing for the Democrat to fear from that realization. The not-so-frozen North. In the heated world of constitutional hermeneutics, the existing debate in jurisprudential theories is between those, let us call them documentarians, who prioritize the words and texts of the Constitution and place all other sources of constitutional meaning in a distinctly and at best secondary category, and those, let us call them doctrinalists, who tend to play down the precise wording of these documents and look to the court's precedential efforts at interpretation. In the same way that few argue that the doctrine is irrelevant to the interpretation of the documents, few also contend that the documents are immaterial to the development of the doctrine. Nevertheless, while generally overlooked or assumed in constitutional debate, the prior question ought to be, what is this Constitution to be interpreted and where is it to be found? The idea that the Constitution stands available and ready for interpretation is a very limited and limiting understanding of a much broader and richer concept. Indeed, such a static idea of a constitution is as misleading as it is mistaken. At least as evidenced by the Canadian context, a constitution is an organic process through which states determine the kind of society and citizens that they are and can become. While there is an acknowledgement that change occurs, it is perceived to be gradual and progressive. Constitutional law's natural development occurs by way of slow growth, not abrupt transformations of the constitutional landscape. While the formal documents and conventions of nationhood represent a privileged resolution of constitutional debate, each attempt to interpret and reinterpret that compromise gives fresh meaning and effect to it. The formal documents of legal statehood no more contain a nation's constitution than an electrocardiogram's chart captures the life of the patient under its observation. Locating the constitution and interpreting it are flip sides of the same coin. In the Canadian context, where the courts locate it and how they interpret it is continually surprising and largely as unpredictable as tossing coins. Reflecting its British roots, the formal documents of the Canadian Constitution are not intended to be complete or definitive. The Constitution comprises both formal and informal sources. Indeed, the critical tension between constitutional documents and legal doctrine is at the heart of Canadian constitutional law. Up to its patriation in 1982, the formal Constitution was a minimalist document that simply laid the basic framework for confederation. Civil liberties were not covered. This did not preclude the courts from using the common law to bridle arbitrary government acts and locate an implied Bill of Rights within the interstices of the British North America Act. These efforts were sporadic and half-hearted, but they spoke to the vibrant possibilities of the common law. Since 1982, of course, the Charter has also placed certain limits on the kind of action that any particular government or legislature can take. For instance, Canadians have a constitutionally guaranteed freedom of communication and the right to life, liberty, and security of the person that government cannot infringe. In this way, contemporary constitutional law is as much about the substantive content of government action as it is about its formal source in the federal system. However, the one thing that constitutional patriation did not do was consolidate or completely codify Canada's constitution. Unlike in the United States, there is no one founding document that claims to occupy the whole constitutional field. For instance, although Section 52 of the Constitution Act of 1982 contains a definition of the Constitution of Canada, it is not exhaustive and is merely exemplary. Indeed, in the New Brunswick Broadcasting case, the Supreme Court of Canada expressly confirmed that the Constitution comprised a variety of written and unwritten sources that were far from finite or fixed in definition and number. Parliamentary privilege is part of the Constitution, even though it is contained in no formal document or text. In short, the Constitution is dealt with in the familiar way of the common law. It is a process as much as a product, and it is a site for development as much as a completed structure. In an early Charter decision, Chief Justice Dickson left little doubt that the constitutional interpretation is as much about substantive values as it is about formal documents. A constitution is drafted with an eye to the future. Its function is to provide a continuing framework for the legitimate exercise of governmental power and, when joined by a bill or a charter of rights, for the unremitting protection of individual rights and liberties. Once enacted, its provisions cannot easily be repealed or amended. It must, therefore, be capable of growth and development over time to meet new social, political and historical realities often unimagined by its framers. The judiciary is the guardian of the Constitution and must, in interpreting its provisions, Bear these considerations in mind. The court must be guided by the values and principles essential to a free and democratic society which I believe embody, to name but a few, respect for the inherent dignity of the human person, commitment to social justice and equality, accommodation of a wide variety of beliefs, respect for cultural and group identity, and faith in social and political institutions which enhance the participation of individuals and groups in society. As the history of constitutional law and decision-making evidences, this process of growth and development is much more open-ended and unstructured than the courts and commentators would have us believe. While the law changes to meet new and different political conditions, it does so in a way that confounds any retrospective claims that such historical evolution is gradual and incremental. Canada's constitution is a place where the nation works through its competing anxieties and shifting aspirations, often in the most abrupt way and with the most unexpected results. For instance, while most of the wording of the Constitution Act of 1867 has not changed in more than 125 years, the meaning and effect of its provisions on the division of provincial and federal powers have gone through a process of continual redefinition. The bulk of constitutional law comprises the many judicial cases that have sought to interpret and apply constitutional arguments to changing social and political circumstances. Indeed, the different substantive effects of the formal acts of amending the Constitution and the informal acts of interpreting it are difficult to pin down. In an important sense, the Constitution is amended every time it is judicially reinterpreted. However, like Canada itself, the terrain is too vast and too variable to do more than sample some of the more striking examples of how the Constitution has changed over the years and how its development has not been the measured and principled growth that its common law defenders insist. Accordingly, what follow are some thematic suggestions about the ways in which constitutional doctrine has shifted and changed over the years. Things that are in the written parts of the Constitution can move in and out of the Constitution over time. Under sections 55, 56, and 57 of the Constitution Act of 1857, the British government retained the right to reserve and disallow Canadian statutes. However, this power has not been exercised since 1878 in the case of reservation and since 1873 in the case of disallowance. Moreover, under Section 90 of the Constitution Act of 1867, the federal government has the powers of reservation and disallowance over provincial laws. But this has not been exercised since 1943. It is the received wisdom that any attempt to utilize these powers would not only be politically objectionable but legally inoperative. Indeed, in 1981, the Supreme Court of Canada stated that reservation and disallowance of provincial legislation, although in law still open, have, to all intents and purposes, fallen into disuse. Nevertheless, efforts to amend the Constitution have sought to include provisions that would explicitly delete such powers from the Constitution. This is an instance where the writing has remained but the meaning has been lost. Another example of this is the overall division of legislative powers between the federal government and the provinces. Whereas Section 91 of the Constitution Act stipulates the federal powers, Section 92 lays out the provincial powers. While each section states that the powers are granted exclusively to each branch of government, the traditional practice is to allow each level of government to legislate on the same issue if the subject matter validly falls under both heads of authority. For instance, traffic laws can fall within both the province's property and civil rights power and the federal government's criminal law power. However, if a valid federal and provincial law conflict, the federal law has paramountcy. The courts have interpreted conflict in a very narrow manner and decided that statutes only conflict where compliance with one law involves breach of the other. Things that are not in written parts of the Constitution can move in and out of the Constitution over time. A good example of the power of judicial interpretation is the case of Sparrow, in which the courts had to interpret the meaning and effect of Section 35 of the Constitution Act of 1982, which reads that existing Aboriginal rights are hereby recognized and affirmed. This section is outside the Charter of Rights and Freedoms and so is not governed by the limiting force of Section 1 of the Charter, which states that all the rights and freedoms in the Charter are subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. Nevertheless, the Supreme Court held that, although the text of Section 35 has no mention of reasonable limits, the federal government has the continuing general power to impose reasonable restrictions on the exercise of any Aboriginal rights protected under Section 35. If this is valid interpretation, it is difficult to imagine in what substantive, as opposed to formal, ways an amendment of the Constitution would differ from it. Things that are written in the Constitution can be limited and controlled by things that are not written in the Constitution. The Canadian Constitution is rife with examples of conventional and customary rules, that is, restricted powers of the Governor-General in terms of exercise of royal assent. While such conventions are seen to be the product of accretion over a period of observant practice, there are instances in which conventions seem to have sprung full-grown into constitutional life. A infamous illustration of this is the so-called Patriation Reference. The Supreme Court was asked to determine if there were legal or conventional requirements that the consent of the provinces be obtained before the federal government could seek amendments to the Constitution, that is, a Charter of Rights, that would affect provincial powers. The court held that there was no legal requirement, but that constitutional convention demanded that there be a substantial degree or substantial measure of provincial consent. In this instance, convention had as much, and more, political bite than legal rule. Things that are written in the Constitution can take on different and occasionally contradictory meanings over time. The history of the interpretation of the peace, order, and good government power granted to the federal government is an object lesson in how words remain but meanings change. Apart from the continuing debate over whether the so-called POG power is a residuary power or whether it includes the whole of the federal power, the extent and scope of this power has taken on different guises as circumstances demand. For instance, it has been used to transfer powers to the federal government over matters of national concern and where there is an emergency, even if such matters would otherwise fall under provincial jurisdiction. The fact that these two doctrines do not sit easily together has not escaped the attention of commentators. Moreover, these doctrines seems to have been fashioned from whole cloth. Another illustration of this phenomenon is the historical tension between the federal government's trade and commerce power under Section 91(2) of the Constitution Act and the province's civil rights and property power under Section 92(13). While the courts have mapped out different spheres of authority in terms of interprovincial and intraprovincial trade, there is still much vagueness and confusion around the details of the doctrine. Things that are written in the Constitution can be circumvented by things that are not written in the Constitution. The problem of delegation exemplifies this well. The key issue is whether the federal and provincial governments can agree to swap powers, that is, can the federal government give the provinces power to levy indirect taxes, a strictly federal power, in return for the provinces giving the federal government power to establish a pension scheme, a strictly provincial power. The Supreme Court of Canada has said that, as there is no express authority in the Constitution, it was not allowed because it would amount to de facto constitutional amendment. However, the courts did allow the federal government and provinces to delegate powers to administrative bodies established under the authority of the other. In effect, what could not be done by legislative delegation could be achieved by administrative delegation. What could not be done directly was done indirectly. The upshot of allowing delegation is that the federal and provincial governments can agree to circumvent the Constitution's written division of powers. Another example of how the written Constitution can be easily end-run is the exercise of the federal spending power. Are there restraints on how the federal government can distribute its considerable tax revenues? For instance, while the administration of hospitals comes within provincial competence, the federal government has exercised great influence over healthcare policy by the conditional deployment of federal funds. The debate is whether the federal government can spend only within its designated fields of federal competence or whether it can also fund projects that fall within provincial competence. The prevailing view is that the federal government can indeed fund in provincial areas, as it is a choice for any province to accept such funding under the conditions it is granted or not. The Supreme Court of Canada has given tacit approval to such practices. This list could go on almost indefinitely, but these given samples are sufficient to make my crucial point, that the law often changes in the most abrupt way and with the most unexpected results. Constitutional law is a baffling mishmash of texts, customs, conventions, ideals, and cases that are only given a semblance of order and continuity after the fact. It is more instructive and more convincing to view constitutional law as a historical and political tour de force of the episodic and unpredictable occasions on which judges and jurists contribute to the efforts of Canadians to come to terms with whom they are and who they want to be. There is no resolution or finality to that process, and there certainly is no gradual getting better all the time progress. Despite the self-understandings of its judicial and juristic practitioners, constitutional interpretation is a volatile tradition of transformative politics. Indeed, David Strauss captures this phenomenon well when he states that the forces that bring about constitutional change work their will almost irrespective of whether and how the text of the Constitution is changed, and the constitutional order would look little different if a formal amendment process did not exist. He ascribes the appreciation that the heart of a constitution is in its almost unhindered judicial interpretation to the finding that constitutional law is best seen as the result of a complex, evolutionary process, rather than of discrete, self-consciously political acts by a sovereign people. I both agree and disagree wholeheartedly with this assessment. I agree in that it is not so much that the political arena in itself does not matter, but rather that the same ideological forces play themselves out through the courts. However, I disagree in that, if Strauss means that the constitutional law's complex, evolutionary process is gradual and contained, the common law does not change in an incremental and principled way. Common law adjudication is itself a political process, albeit one that is different than the legislative branches of government. It is a work in progress affected by and responsive to its social, historical, and political environment. It is to a constitutional example of how that occurs that I now turn. This time I use an American example. The Glucksburg opening. Faced with a challenge to Washington's legislative prohibition of assisted suicide, the Supreme Court of the United States had to grapple with the Due Process Clause of the 14th Amendment, which declares that states may not deprive any person of life, liberty or property, without due process of law. The court decided that the right to die was not presently so fundamental a liberty that it was protected by the Due Process Clause and, therefore, its infringement by government was permissible. Although the Supreme Court was unanimous in its decision, it was divided over the appropriate reasoning for this decision. The case has predictably engendered much debate and disagreement. However, apart from the popular and strictly ethical discussion about the propriety of right-to-die statutes, the Glucksburg decision has become the focus of considerable jurisprudential engagement. Although there were 6 separate judgments, the more expansive judgments of Chief Justice Rehnquist and Justice Souter have commanded the most attention. Each represents a very different approach to due process analysis and, thereby, to the freighted and contested judicial task of charting the connection between legal analysis and ethical or political values in constitutional and common law decision-making generally. In short, jurists have critically examined the jurisprudential basis on which the competing judges approach that task and the overall style of adjudicative reasoning. In speaking for a majority of the Supreme Court in Glucksburg, Chief Justice Rehnquist relied on a fairly predictable approach to substantive due process doctrine. While he accepts that the 14th Amendment's protection of liberty is broader than a mere absence of physical restraint, he insists that the limits of such fundamental values must be studiously noted and observed. In order to ensure that there is a requisite degree of objectivity to the recognition of such values, Rehnquist demands that only those values that are deeply rooted in the nation's history and traditions can be accorded constitutional sanction. Accordingly, he holds that, because for over 700 years, the Anglo-American common law tradition has punished or otherwise disapproved of both suicide and assisting suicide, there is no legitimate ground on which to recognize a protected right to assisted suicide. Indeed, Rehnquist is so opposed to a balancing of competing interests that he is prepared to concede that there might not be any principled basis for defining the actual reach and extent of the fundamental rights that are protected. For him, the vaunted objectivity of the traditional process outweighs any perceived gains to be made by a more nuanced yet less neutral approach to substantive due process. In going out of his way to defend the traditional analysis, the Chief Justice clearly and expressly has the alternative method of Justice Souter in his jurisprudential sights. In contrast, Justice Souter's approach to the substantive due process doctrine is much less historicist and more critical than Rehnquist's. He is not prepared to treat what is historically rooted as being constitutionally decisive. While the embeddedness and longevity of a particular social practice is an important factor in determining its constitutional protection, it is not the exclusive or necessarily decisive one. Justice Souter offers a plausible telling of the doctrine in which the absolutism of Dred Scott and Lochner has given way to a more restrained approach that favors legislative intervention and curbs only arbitrary and egregious exercises of that power. For Souter, this entails the scrutiny of a legislative resolution, perhaps unconscious, of clashing principles, each quite possibly worthy in and of itself, but each to be weighed within the history of our values as a people. Rather than a logical deduction from some textual first premise, Souter treats the doctrine as demanding a comparison of the relative strengths of opposing claims, which empowers the courts not to substitute one reasonable resolution of the contending positions for another, but to supplant the balance already struck between the contenders only when it falls outside the realm of the reasonable. The judicial challenge is to avoid the absolutist failing of many older cases without embracing the opposite pole of equating reasonableness with past practice described at a very specific level. To achieve this, Souter draws on the idea of ordered liberty, which comprises a continuum of rights to be free from arbitrary impositions and purposeless restraints. As the source for the legitimacy of this balancing approach to substantive due process analysis, Souter points to the celebrated dissent of Justice Harlan in Bowe v. Ullman, where he states the following: Due process has not been reduced to any formula, its content cannot be determined by reference to any code. The best that can be said is that through the course of this court's decisions it has represented the balance which our nation, built upon postulates of respect for the liberty of the individual, has struck between that liberty and the demands of organized society. If the supplying of content to this constitutional concept has of necessity been a rational process, it certainly has not been one where judges have felt free to roam where unguided speculation might take them. The balance of which I speak is the balance struck by this country, having regard to what history teaches are the traditions from which it developed as well as the traditions from which it broke. That tradition is a living thing. A decision of this court which radically departs from it could not long survive, while a decision which builds on what has survived is likely to be sound. No formula could serve as a substitute, in this area, for judgment and restraint. There are many motifs in these famous dicta, no formulaic solutions, the balancing of interests, a rational process, the caution against roaming judges, the lessons of history, the force of tradition, the organic quality of tradition, and restrained judgment, that suitor seeks to draw together into an integrated and dynamic account of what substantive due process analysis demands and has become. However, suitor is much more ambitious in the claims that he makes for this style of judicial practice. In stressing that this approach calls for a court to assess the relative weights or dignities of the contending interests, he underlines the fact that this judicial method is familiar to the common law. This, of course, is not surprising. Indeed, it would be odd if the difference between the style of constitutional and common law adjudication was substantial or striking, as it is exactly the same judges that engage in both. Nevertheless, suitor is quick to point out that there are two important constraints in constitutional matters, particularly when one is undertaking substantive due process review. First, there must be some objective basis to the values protected that goes beyond the merely personal and private notions of justice of any particular judge. Second, having identified the existence of fundamental values, one must determine whether the legislation's justifying principle, critically valued, is so far from being commensurate with the individual interest as to be arbitrarily or pointlessly applied that the statute must give way. In other words, it is not enough to simply locate a reasonable resolution of contending values that differs from the terms of the legislation under review. Notwithstanding these riders, suitor is clear and open in his belief that substantive due process analysis is simply a particular kind of common law adjudication. The basic components of the common law mindset are adapted to the specialized demands of the constitutional context. In undertaking this general adjudicative task, suitor urges an explicit attention to detail that is no less essential to the intellectual discipline of substantive due process review than an understanding of the basic need to account for the two sides in the controversy and to respect legislation within the zone of reasonableness. Again, drawing on Harlan's dissenting judgment, suitor observes the following. Just as results in substantive due process cases are tied to the selections of statements of the competing interests, the acceptability of the results is a function of the good reasons for the selections made. It is here that the value of common law method becomes apparent, for the usual thinking of the common law is suspicious of the all-or-nothing analysis that tends to produce legal petrification instead of an evolving boundary between the domains of old principles. Common law method tends to pay respect instead to detail, seeking to understand old principles afresh by new examples and new counterexamples. The tradition is a living thing, albeit one that moves by moderate steps carefully taken. The decision of an apparently novel claim must depend on grounds which follow closely on well-accepted principles and criteria. The new decision must take its place in relation to what went before and further, cut a channel for what is to come. Exact analysis and characterization of any due process claim is critical to the method and to the result. Having laid out what he believes to be the best and most appropriate approach to substantive due process analysis in particular and common law adjudication in general, suitor turns to the resolution of the concrete dispute before the Supreme Court. In line with his defended approach, he asks whether, as part of the traditionally recognized claims to autonomy in deciding how their bodies and minds should be treated, patient's requests to obtain the services of a physician in committing suicide is said to enjoy a tradition so strong and so devoid of specifically countervailing state concern that denial of a physician's help in these circumstances is arbitrary when physicians are generally free to advise and aid those who exercise other rights to bodily autonomy. After engaging in a close and contextual survey of the law, practices, and arguments in play, suitor concludes that, although the importance of the individual interests are substantial, whether that interest might in some circumstances, or at some time, be seen as fundamental to the degree entitled to prevail is not, however, a conclusion that I need draw here. for I am satisfied that the state's interests are sufficiently serious to defeat the present claim that its law is arbitrary or purposeless. In reaching this conclusion, suitor accepts the practical difficulties in controlling or limiting the exercise of the alleged right. Indeed, he is very committed to ensuring that the courts do not step on the toes of legislatures who have a much greater claim to the open floor of political dancing and are authorized to take the choreographic lead in deciding the style and direction of political movement. When it comes to recognizing the existence and scope of the unremunerated rights of the Due Process Clause, it will not be arbitrary for the legislature to act when the facts necessary to resolve the controversy are not readily ascertainable through the judicial process, but they are more readily subject to discovery through legislative fact-finding and experimentation. To answer otherwise would simply create a constitutional regime too uncertain to bring with it the expectation of finality that is one of this court's central obligations in making constitutional decisions. Nevertheless, in line with the contextually nuanced imperative of Harlan's favored methodology, suitor concludes that I do not decide for all time that respondent's claim should not be recognized. I acknowledge the legislative institutional competence as the better one to deal with that claim at this time. In the rush to jurisprudential judgment, Soapy Sam Dworkin and Bulldog Posner have, as expected, played the leading roles. Predictably, Dworkin chastised the court for its failure to fully understand the philosophical dimension of adjudication and the ethical responsibilities of judges in interpreting the Constitution. Having joined with other leading liberal philosophers in submitting an amicus brief in support of the respondents, Dworkin condemned the decision not simply because it found resoundingly against his particular moral views on assisted suicide, but because the judges did not properly appreciate their sophisticated task as constitutional interpreters. Dworkin has little good to say about Rehnquist, Scalia, and Thomas, whose historicist approach, that is, insisting that what has been accepted as politically fundamental is what is legally fundamental, ignores the philosophical element of constitutional adjudication, thereby reducing it to a conservative enterprise in empirical inquiry. In contrast, although suitor's judgment is reasonable in principle, Dworkin remains unconvinced that the facts are so sufficiently in dispute as to warrant a hands-off approach by the courts. Taking the Glucksberg bait, Posner chastises Dworkin for his mistaken views on both how the right to die claims should be resolved and what valid constitutional adjudication should comprise. He is adamant that the Supreme Court is correct to stay out of the moral debate around the right to die issue and to prefer the solid earth of policy analysis to the soggy turf of moral philosophy. In his view, there was no obviously shared or objective moral resolution available. Democracy is at work and seemingly proceeding satisfactorily without judicial interference. Further, he notes that the issue demands very complex rules of implementation that courts are ill-equipped to draft. For Posner, therefore, Glucksberg is a prime example of the benefits and legitimacy of construing constitutional adjudication as a practical task of institutional instrumentalities, which most judges can do, as opposed to an abstruse exercise in philosophical reflection, which most judges cannot. While the spat between Dworkin and Posner goes to the contemporary heart of much jurisprudential debate, there is another take on the Glucksberg decision that is worthy of serious consideration. It isn't his suggestion that Justice Souter's judgment ought to be celebrated as a paradigm example of what it means to take a sophisticated and Gadamerian-inspired approach to the judicial task. Souter's opinion persuasively describes the adjudication of fundamental rights as a hermeneutical rhetorical project in terms that Gadamer would endorse, even though Souter articulates his reasoning in the idiom of contemporary constitutional discourse. Moreover, Mtz maintains that Souter's legal pragmatics taps into the natural law tradition, albeit in a non-traditional and new form. At the heart of Souter's approach is alleged to be not only the outright denial of adjudication as a technical and pseudo-scientific exercise in textual exegesis, but an enthusiastic embrace of the hermeneutical idea. Mtz rephrases Souter such that he is seen to assert that adjudication involves immersion in an organic tradition of reasoned judgment and principled argumentation in which a balanced mediation of past commitments and present concerns is negotiated. Inspired by the work of Linfuller and Lloyd Weinrib, Mtz puts together a plausible case for his informed assessment that Souter's practice affirms that rhetorical knowledge is possible and that human understanding is dialogical, and that this mode of conversational understanding acknowledges the natural law groundings of legal practice while simultaneously rendering the law current by means of application and judgment. Accordingly, Justice Souter's opinion warrants a close and critical reappraisal in light of these ambitious claims. Nevertheless, although Souter's judgment and its thoughtful reflection on adjudicative legitimacy are a vast improvement on the other American judicial approaches on offer, I do not believe that it can bear the jurisprudential weight that hermeneutical jurists like Mtz wish to place on it. As with my treatment of Gadamer and legal hermeneutics generally, I intend to take the basic claims that Souter makes and, rather than hedge on their radical import as Gadamer, and Suter do, push through on them in an uncompromising manner. When this is done, they each appear to be quite conservative in that they are unwilling to take seriously the radical implications of their own views. However, my quarrel with Suter and Mtz is less with how they depict the operation of the common law than with the claims that they make for this account. Indeed, while I agree in large part with their description of the common law method, I disagree that this hermeneutical method can live up to the traditional expectations that are placed upon it. Rather, it fails to deliver on the formalist promise that common law adjudication is a bounded and objective process that can give rise to relatively determinate and predictable resolutions of disputed controversies. In short, it cannot distinguish legal decision-making from overtly political or ideological disputation. Consequently, rather than for a compelling illustration of Gadamerian-inspired legal argumentation, Suter's judgment actually gives credence to the alternative hermeneutical account of the common law that I am proposing. There is no method that can absolve people from the responsibility and challenge of constantly arguing and re-arguing what should and should not be done in particular contexts at particular times, and there is no escaping politics to a technical or sanitized conversation in which the basic struggle over whose interests count and what they count for can be sidestepped. Of course, such a debate will itself be ungrounded and political. There is no way to talk about politics that is not itself political. Politics, like the law in which it plays itself out, is a work in progress. The Suter move. In many ways, Suter's judgment is a jurisprudential tour de force. It takes the opportunity presented by the particular dispute to offer a reflective and expansive general justification of adjudicative responsibilities in a constitutional democracy. In this way, Suter attempts to provide little less than a comprehensive theory of common law decision-making that, in its emphasis on attention to detail, historical erudition, conceptual flexibility, and critical insight, is as ambitious as it is sophisticated. Although Justice Suter might never have heard of, let alone read, Gadamer, his opinion in Glucksberg is seen to be not only the best example of such a pragmatic approach to law and adjudication but also a passable defense of the propriety of so proceeding. Like Molière's Monsieur Jourdan, he might be forgiven for exclaiming, Par ma foi, il y a plus quartet sans cage de Gadamer sans cage sus run. As his judgment is not for the jurisprudentially timid at heart, it is not surprising that it should have received such critical attention and lively debate. While there is much to comment on in Suter's judgment and its general jurisprudential reception, I restrict my response to the effort to treat it as an exemplary illustration of philosophical practice in the mode of Gadamerian hermeneutics. That having been said, such a response will touch on a wide range of theoretical issues and practical controversies. Accordingly, as part of that critique, I utilize Suter's sophisticated opinion as a convenient route into three of the central problems that define and dog contemporary jurisprudence. First, that there is some objective basis to the protected values and the methods used to ascertain them that goes beyond the merely personal and private notions of justice of any particular judge. Second, that it is possible for judges to identify arbitrary impositions and purposeless restraints by legislative bodies in a strictly legal as opposed to openly political way. And, third, that there exist recognizable traditions in law that allow judges to engage with contested matters of social, legal, and judicial practices in a determinate and defensible way. Or, to put it more bluntly, that there is a practicable way of resisting the critical claim that law is politics. My quarrel with Suter, and, to a lesser extent, Gadamer is not so much with how they depict the prosaic operation of the common law but more with the extravagant claims that they make for their account. Indeed, while I agree in large part with their pragmatic description of common law adjudication, I disagree that this hermeneutical method can live up to the traditional expectations that are placed on it. It fails to deliver on the formalist promise that common law adjudication is a bounded and objective process. It cannot give rise to relatively determinate and predictable resolutions of disputed controversies in a way that distinguishes legal decision-making from overtly political or ideological disputation. Accordingly, having offered an alternative and critical hermeneutical account of the common law, it is incumbent on me to make good on my claim that law is politics. I need to show that, far from being a check on or remove from political debate, constitutional adjudication is another site, albeit stylized and technical, for political confrontation in which anything might go. In short, I must demonstrate that Justice Suter's judgment implodes from the hermeneutical force of his own arguments. Whatever the claims that he or his jurisprudential apologists make for it, his judgment actually confirms rather than refutes that there is no method that can absolve judges or anyone else from the responsibility and challenge of constantly arguing and re-arguing what should and should not be done in particular contexts at particular times. As Suter himself said in an earlier judgment, even when jurists reason from shared premises, Some disagreement is inevitable, but that is to be expected in the application of any legal standard which must accommodate life's complexity. Moreover, Souter's Glucksberg judgment corroborates rather than confutes that there is no escaping from politics, especially through a resort to reason, judgment and tradition, to a technical or sanitized conversation in which the basic struggle over whose interests count and what they count for can be sidestepped. Read with a critical eye. The judgment and its ensuing juristic reception make the critical case that law is politics in that adjudication is only bounded and objective insofar as its bounds and values are themselves thoroughly political and revisable. It will be remembered that, in determining the existence and scope of any constitutionally protected right to die, Souter considered that his judicial task is not to substitute the court's view of what is or is not the most reasonable balance of competing interests, but to check whether the legislative view falls outside the realm of the reasonable and imposes arbitrary imposition and purposeless restraints. To do this, judges must be engaged in reasoned judgment that will ensure that they do not indulge the merely personal and private notions of justice of any particular judge. This reasoned judgment will eschew all or nothing analysis in terms of either textual or extratextual absolutes, instead, operating at the proper level of generality and paying respect to detail. Judges must restrict those values deserving constitutional protection only to those exemplified by the traditions from which the nation developed, or revealed by contrast with the traditions from which it broke. Consequently, after such an exact analysis, Justice Souter reached the conclusion that, while the importance of the individual interest here cannot be gainsaid, and whether that interest might in some circumstances, or at some time, be seen as fundamental, I am satisfied that the state's interests are sufficiently serious to defeat the present claim that its law is arbitrary or purposeless. Although Souter accepted that there is a tradition of extending patients' rights to bodily integrity and to medical care, he maintained that the state's slippery slope concern is fairly made out here, because there is a plausible case that the right claimed would not be readily containable by reference to facts about the mind that are matters of difficult judgment, or by gatekeepers who are subject to temptation, noble or not. There is no doubt that Souter's judgment is sophisticated and plausible. It offers a reasoned and reasonable intervention in a controversial debate. Indeed, there is much in Souter's excursus on common law method that emphasizes the Gadamerian themes of historical context, performative dynamism, and organic tradition, just as results in substantive due process cases are tied to the selections of statements of the competing interests. The acceptability of the results is a function of the good reasons for the selections made. Indeed, there are three particular traditions, social, legal, and judicial, that are in play in Glucksberg and that Souter maintains are receptive to the hermeneutical kind of reasoned judgment that he recommends. However, there are several argumentative maneuvers or rhetorical ruses that rob the judgment of the hermeneutical cogency that it claims and craves. In the Gadamerianesque prose adopted by Souter, if the acceptability of the result is a function of the good reasons given, then the result is not acceptable because the supporting reasons are wanting and not persuasive. Despite the Gadamerian trappings, there is still the underlying commitment to the idea that adjudication is a largely technical endeavor that demands rigorous discipline, that lends itself to exact analysis, that is amenable to close criticism, and that repays attention to detail, all of which can be achieved in a politically neutral manner. Contrary to Souter's, and Mtz's, Gadamer's, and most other traditional jurists' fervent hope, it simply is not possible to perform this judicial task in a way that makes the legal outcome completely independent of the merely personal and private notions of justice of any particular judge. Such notions can be concealed or overlooked, but they cannot be excluded or eliminated. A closer reading and parsing of Souter's arguments makes such a critical evaluation both clearer and more convincing. The first traditions that Justice Souter looks to are those social practices that surround and inform the particular right claimed. He examines the constitutional, legal, and social history of suicide and physician assistance to the dying. However, as Souter recognizes, there is not only no one tradition but the several existing traditions are indeterminate in scope and often compete with each other. This will mean that it is crucial to identify a device by which to determine the proper level of generality at which these competing traditions are to be characterized so as to ascertain which is entitled to constitutional protection. This, of course, is where reasoned judgment enters the doctrinal picture. Selecting among such competing characterizations demands reasoned judgment about which broader principle, as exemplified in the concrete privileges and prohibitions embodied in our legal tradition, best fits the particular claim asserted in a particular case. To do this with exactitude, Souter recommends a number of requirements, such as applying concepts of normal critical reasoning, as pointing to the need to attend to the levels of generality at which countervailing interests are stated, or as examining the concrete application of principles for fitness with their own ostensible justifications. Mindful that all of this has to be done in an objective and neutral manner without illicit reliance on the merely personal and private notions of justice of any particular judge, Souter has sent judges on a sleeveless errand. There is no way that they can complete such an analysis as a purely technical or strictly legal matter. Once it is accepted that reliance on dominant traditions without more is unjustified, Souter is into the dangerous political game of deciding which traditions, to paraphrase Justice Harlan, are those from which the country should develop and those from which the country should break. Because tradition is a living thing, it is the self-assumed responsibility of judges to decide which parts of the tradition should die in order for the tradition to thrive. This is a profoundly political task. It becomes more so and not less so, when it is allegedly done by deference to existing traditions. Although the appeal to tradition is only meaningful if that tradition is sufficiently determinate and discrete, history shows that traditions are notoriously imprecise and that they are infuriatingly difficult to pin down. Like anything and everything else, traditions are not so much discovered as constructed in the act of following them. Even when pitched at a classificatory level of great specificity, tradition does not speak for itself and cannot excuse judges from making critical and contestable choices. This seems to suggest that tradition is one factor in the doctrinal decision of whether to recognize certain liberties as sufficiently fundamental, but it is not the only, and certainly not the decisive, criterion. Indeed, although the right claimed in Glucksberg is quite discrete as it involves a limited group, that is, doctors, in limited circumstances, that is, dying and suffering patients, it is next to impossible to identify a physician-assisted right to die tradition in Anglo-American law and society. Rehnquist surely has the best of this argument in Glucksberg. While there are incipient signs that such a tradition might be taking shape, for example, there has been a general decriminalization of suicide. The claim that such a tradition has moved beyond some initial threshold of viability would mean that almost any practice could claim to be a tradition. This would result in almost anything claiming to be worthy of at least being taken seriously in constitutional discourse, even if not ultimately accepted as a fundamental value. Moreover, if tradition is the decisive test of whether something is a fundamental interest or not, many of the leading cases in the substantive due process tradition would not cut the constitutional mustard. The most spectacular example of this is Roe. There was no obvious tradition in Anglo-American legal tradition of such a right being recognized. If anything, the denial of such a right was more an integral part of any extant tradition. Souter's efforts to steer clear of this political terrain are based on the possibility that judges can restrict themselves to policing the boundaries of reasonableness. Rather than argue over whether one approach is more or less reasonable than another, judges can confine their analysis to whether the legislative intervention falls outside the realm of the reasonable and whether its justifying principle, critically valued, is so far from being commensurate with the individual interest as to be arbitrarily or pointlessly applied. However, this assumes that what is and is not arbitrary and purposeless is seen to reside outside the historical flow of social tradition and, therefore, outside politics. This smacks of the most ahistorical and inorganic approach to tradition. The maneuver only works if the arbitrary and the purposeless are simply givens that can be discovered, not chosen, yet the history of America's social traditions suggests that such assumptions are invalid. There is nothing arbitrary about, for example, bigotry. While racist or sexist prejudice might be unreasonable, it is not arbitrary or purposeless. Bigots have as many reasons for their beliefs and actions as liberals. The identity of the arbitrary and purposeless has to be argued for, as it is inside and not outside the political forces that it is meant to regulate and evaluate. The fact that there might be almost complete agreement on whether certain values or activities are outside the pale of reasonableness does not make such a conclusion any less political. It is not about whether there are reasons, there always are. It is about whether those reasons are considered good or bad ones. After all, racism and sexism of the most rampant kind were once, as Souter would agree, so broadly accepted and deeply rooted that they brooked little challenge, at least among those with political power and franchise. In the world of the past, it would have been the anti-racist or the feminist who would have been arbitrary and purposeless. Furthermore, if a reliance on social tradition, albeit in a modified and sensitive manner, is used to identify constitutional rights, it will be those minorities who most need protection against majority views that will be denied constitutional protection. Unless tradition is expanded to include whatever people have done whether in support or opposition to traditional values, constitutional protection will only extend to those whose values and activities conform with the tradition and who are less likely to require such protection. Once tradition is interpreted so broadly and indiscriminately, its legal use becomes entirely vacuous because there is no legal test, which is not itself political, to organize social practices into acceptable and objectionable traditions. Mindful that the level of generality is so vague and so variable, it is possible to use tradition to support all kinds of competing positions. After all, it was not so long ago that the use of racial discrimination was deeply rooted in America's constitutional and demographic history. More recently, the Supreme Court has accepted that homophobia, while again deeply rooted in the nation's constitutional and demographic history, is a tradition from which the courts should break rather than on which they should build. Mindful that it depends on the level of generality at which such so-called tradition analysis is plausibly made, it is not exactly a stretch to treat private homosexual relations as falling within the established intimacy and privacy concepts of constitutional liberty. What determines the proper level of generality remains as elusive and as crucial as it has always been. There is no proper level of generality without some initial attachment to a pre-existing commitment to what liberty might entail. Such a question goes to the very heart of politics, not law, or, as I have sought to emphasize, law is politics because the heart and soul of law is politics. A traditional stance. Moving on from social tradition, one can apply a similar kind of critique to reliance on legal tradition. Indeed, the effort to rely on a fixed or determinate tradition of substantive legal doctrine is as weak and unsuccessful as the judicial effort to utilize social tradition to ground constitutional interpretation. Both traditions are so numerous and imprecise that they can justify almost any reading. Indeed, this resort to tradition tends more to reinforce than resolve the problem because it is difficult to ascertain what the controlling tradition would be, constitutional or social, over and above a particular judge's honest and evaluative conviction about what it should be. Suitor only grounds his decision by building a foundation for it and, once history moves, that ground will itself be rendered unstable and disclosed as only the function of suitor's contingent and personal commitments, not its grounding. He fails to grasp that legal tradition is not simply a process that is to be known and thereby governed. It is part of an active engagement in which tradition is a genuine partner in dialogue with its judicial interlocutors and, in engaging in the dialogue, both the tradition and the interlocutor are transformed into a communion in which, they, do not remain what, they, were. I want to add that that communion is itself temporary, provisional, and contingent. It is a work in progress that stands inside, not outside, the matrix of ideological forces that drive the historical process of rhetorical tradition. As Gadamer reminds us, even if he often forgets it himself, from the hermeneutical standpoint, rightly understood, it is absolutely absurd to regard the concrete factors of work and politics as outside the scope of hermeneutics. When it comes to legal traditions, it has to be remembered that, as well as being multiple and fractured, they are capable of being abandoned when circumstances demand. Although courts are understandably reluctant to break from a long-standing legal tradition, they are not only prepared to do so but place an obligation on themselves to so act at times. For instance, in Planned Parenthood v. Casey, the Supreme Court divided over whether Roe should be overruled. Speaking jointly for the court, with Justices O'Connor and Kennedy, Justice Souter stated that there are moments when the court best fulfills its constitutional duty by repudiating earlier lines of cases. In constitutional adjudication, as elsewhere in life, changed circumstances may impose new obligations, and the thoughtful part of the nation could accept each decision to overrule a prior case as a response to the court's constitutional duty. According to Souter, this should occur when the court would have to pay a terrible price for failure to act, as was the case in both West Coast Hotel and Brown. However, cautioning that each generation must learn anew that the Constitution's written terms embody ideas and aspirations that must survive more ages than one. He maintained that Roe not only did not warrant overruling, but that its repudiation would seriously weaken the court's capacity to exercise the judicial power and to function as the Supreme Court of a nation dedicated to the rule of law. In short, if the stakes are high enough, the fallout sufficiently severe, and the judges are so disposed, the breaking with established constitutional tradition will occur. This is exactly what the minority proposed to do. It was not that Justice Souter and his colleagues thought that such a course of action was entirely illegitimate, simply that Casey was not the appropriate occasion. It was an ideological call, not a legal one, about social circumstances and political climate. If this general critique is pertinent for social and legal traditions, it is doubly applicable for the other judicial tradition that is in play. Beginning with the decision in Glucksberg itself, a cursory familiarity with substantive due process doctrine and constitutional law in general easily confirms that there is no one tradition of judicial justification. Whatever the topic on which they join issue, the judgments of the Supreme Court, and all other inferior courts, are always engaged in a concerted effort to legitimate their decisions by virtue of the method adopted. In Souter's terms, they realize that the acceptability of the results is a function of the good reasons given. Nevertheless, what amounts to reasons, let alone good ones, is as divided as almost any other item on the constitutional agenda. Sometimes, the disagreement remains muffled and marginal, at other times, it becomes voluble and central. Indeed, much of the disagreement between Souter and Rehnquist is framed in terms of their respective approaches to the problem of determining whose interests are to receive constitutional protection. Nevertheless, although the general formal methodology adopted will lean toward a particular substantive preference, it will not be decisive. To believe otherwise would be to disregard entirely Gadamer's primary insight that there is no necessary connection between truths and methods, whether one is an originalist, a textualist, an interpretivist, or any other stripe of constitutional jurist will not of itself determine the result reached. While the adoption of a specific interpretive approach on a specific occasion will make certain outcomes more likely and more justifiable than others, it is the substantive political prejudices or, as Souter has it, the merely personal and private notions of justice of any particular judge, that begins and ends the process. At the end of the day, it seems apparent that Souter was not sufficiently enamored of the claimed physician-assisted right to die as to warrant its recognition. However, this was not because it failed the tradition test but because it was not fundamental in Souter's scheme of justice. If he had wanted to recognize such a right, there were ample rhetorical resources for him to draw on in fashioning a hermeneutically adequate argument. However, as with the decision he actually made, the acceptability of the result will be a function of the good reasons given and, without some account of the particular prejudices that motivate and constitute him, those reasons are lacking. As Gadamer himself noted, there is undoubtedly no understanding that is free of all prejudices. Gadamer insisted that a large part of the hermeneutical performance entailed a sustained effort to distinguish the true prejudices, by which we understand, from the false ones, by which we misunderstand, even if this cannot be done outside the very historical, and, therefore, political, process at which efforts are being made to understand. Souter seems not to take seriously the fact that any method, including his proffered reasoned judgment, will retain some element of prejudice. For Souter, it is the merely personal and private notions of justice of any particular judge or what I call simply political commitments. As Gadamer warned, unless there is a constant struggle to identify rather than to ignore those prejudices, interpretation will become enslaved to the tyranny of hidden prejudices that makes us deaf to what speaks to us in the tradition. It is the act of hiding those prejudices that is the problem, not the acknowledgement of their existence. Interpretation is part of, not apart from, political commitments. The refusal to recognize the importance of those political commitments mean that tradition loses its vital quality as a living thing or, as I put it, a work in progress. While Souter, and others are content to leave the sources and direction of its development to some almost mystical historical Volksgeist, I prefer to see it for what it is, a heuristic device that does the bidding, no matter how tentative and provisional, of its social artisans and judicial arbiters. Viewed in this light, Justice Souter's judgment in Glucksburg is not the masterful piece of hermeneutical artistry that he wants it to be or his jurisprudential admirers wish it to be. The reasons given for the result are not good enough to warrant its acceptability. If Mtz's suggestion that Souter's opinion persuasively describes the adjudication of fundamental rights as a hermeneutical rhetorical project in terms that Gadamer would endorse is right, then Gadamer's hermeneutical rhetorical project is seriously deficient and in need of substantial reformulation. That is exactly what I have recommended. It is only on a more critical and radical reading of Gadamer that it is possible to provide a compelling account of common law adjudication. While there is some objective basis to the protected values and the rhetorical methods used to develop doctrine and to decide cases, there is none that stands entirely apart from the merely personal and private notions of justice of any particular judge. There is a constant toing and froing between the objective and the personal and between the public and the private that defines and energizes legal and judicial traditions. Understood in this way as works in progress, there do not exist recognizable traditions in law that allow judges to engage with contested matters of social practices in an objectively determinate and neutrally defensible way because those traditions are too much part of the very politics that they are claimed to bypass or obviate. To rework Justice Souter's chosen Gadamerianesque line that the acceptability of the results is a function of the good reasons given, it is that the goodness of the reasons, that is, their rhetorical effectiveness, and the acceptability of the results, that is, their political resonance, interact and function together. What counts as good reasons is not separate from the political context in which they arise and into which they intervene. In the particular debate at hand in Glucksburg, the quality and ferocity of the political forces at work is much more muted, although not absent, than in other contested areas of constitutional controversy. such as abortion and homosexuality. Like all the related questions of death and dying, assisted suicide provokes an endless debate. It is not unreasonable to assert that, while medical technology has done much to improve health and combat suffering, it has also created entirely new situations that have so affected humankind that it has changed the world. In such a society, the power to define and control this continuing social revolution is inevitably political. In the same way that philosophy has a history and, therefore, a politics, so moral philosophizing about life and death is embedded within certain historical protocols of professional and technological power. Medical practice and the health industry begin to construct and validate the rationality by which its problems and their solutions are resolved. As the pace of medical innovation ever quickens, anxiety has become so pervasive and profound that there has come to exist a state of epistemological turbulence, in which, rather than studying social phenomena as if they were natural phenomena, scientists now study natural phenomena as if they were social phenomena. Against this chilling backdrop, it is naive at best for Souter to maintain that the constitutional dimension of these matters can be settled in an exclusively technical and legal manner that obviates or sidesteps reference to these deeper and more tumultuous debates. Although Justice Souter is not short of company in this conceit, he is no less culpable for his presumption. Reason is as disciplined as disciplining in its interaction with the socio-politics of bioethics and healthcare. A French connection. Perhaps more than most, Canada is a country that has a continuing debate about its constitutional arrangements. This debate covers not only the legal structure of such arrangements but also the process by which such a structure can connect to the political debate for its alteration. Although this leads to more than its fair share of national angst, Canada has at least been obliged to attend to the legitimacy and substance of the basic building blocks in its constitutional toolkit. Of course, at the heart of this contemporary debate is the persistent problem of French-speaking Quebec's continued relationship with the rest of Canada. This takes many different shapes and forms, but the pressing issue is under what conditions, if any, can Quebec determine its own constitutional and political fate. This brings to the fore a whole host of difficult and enduring concepts and practices: democracy, sovereignty, self-determination, federalism, and, of course, the rule of law. Few constitutional challenges call so acutely into question the whole issue of what constitutions are, where they are to be found, and how they are to be given meaning. A few years ago, the Supreme Court of Canada was pushed reluctantly into the breach and required to provide its legal judgment on whether and under what circumstances Quebec might be able to secede unilaterally from Canada. The decision of the Supreme Court is an object lesson in the dilemmas that confront any theoretical efforts to give meaningful and legitimate practical content to constitutional law in a modern democracy. The fact is that the Supreme Court offered a more sophisticated account of the problem and its possible solutions than much of the then existing jurisprudential reflection. The main question to be answered was, under the Constitution of Canada, can the National Assembly, Legislature, or Government of Quebec effect the secession of Quebec from Canada unilaterally? The Supreme Court decided that it could not. Any political decision to secede is constrained by and must be implemented in accordance with existing constitutional commitments. However, in a subtle analysis of the relation between democracy and the rule of law, it also held that, if there was a clear democratic vote in favor of secession, the rest of Canada would be obliged to negotiate with Quebec over the terms of its withdrawal from the Canadian Confederation. Balancing constitutional rights and obligations as well as legal structures and political initiatives, the Supreme Court sought to clarify the delicate interplay between law and politics in a democracy and its own role in the dynamic confrontation. For instance, it decided that, whereas the legal order of the Constitution prevented unilateral acts and required collective action, what constitutes a clear democratic vote and legitimate negotiations was a political matter that fell outside the legal mandate of the courts. As a unanimous Supreme Court concluded, the task of the court has been to clarify the legal framework within which political decisions are to be taken under the Constitution and not to usurp the prerogatives of the political forces that operate within that framework. In reaching its specific decision and justifying it generally, the Supreme Court's judgment resonates strongly with the themes of my critical perspective. In examining the importance and limits of democratic process, the nature and status of the rule of law, and the relationship and balance between the two, the Supreme Court adopted a jurisprudential modus operandi that reflected, even if it did not explicitly embrace, the kind of work-in-progress dynamic approach to common law adjudication that I have been describing. Recognizing that the written constitutional rules must be interpreted in light of the underlying unwritten principles that have been developed over time, the Supreme Court took the view that any particular ruling must incorporate both the documentarian and doctrinalist sources of constitutional law. The enacted text is to be understood against the foundational principles of democracy, federalism, the rule of law, and respect for minority rights. Constitutional texts are primary, but they do not exhaust the Constitution, and there is an historical lineage whose underlying principles inform and sustain the constitutional text. One of the essential interpretive considerations is the principle of democracy. However, the Supreme Court realizes that the meaning and demands of that principle are far from self-evident or universally accepted. While Anglo-Canadian constitutional history has tended to equate this with majority rule, democracy consists of much more. It is not simply concerned with the process of government. There is a substantive dimension that cannot be overlooked. According to the Supreme Court, these substantive goals include, to name but a few, respect for the inherent dignity of the human person, commitment to social justice and equality, accommodation of a wide variety of beliefs, respect for cultural and group identity, and faith in social and political institutions which enhance the participation of individuals and groups in society. However, and of vital importance to a critic like me, the Supreme Court concedes that what those values are, how they can be defined, and how they interact is itself never fixed but is part of the continuing debate over what democratic commitment entails. A democratic system of government is committed to considering dissenting voices and seeking to acknowledge and address those voices in the laws by which all in the community must live. In adopting such an approach, the Supreme Court seems to have made a giant leap beyond many of its juristic counterparts. Its judges recognize that constitutional law is fluid and evanescent, not fixed and unmoving. This broader and more nuanced understanding of democracy leads to an obvious difficulty. The two fundamental principles to which constitutional democracy is committed, that is, majoritarian process and substantive justice, are, at worst, incompatible and, at best, in the most severe tension. According to one principle, the will of the citizens as expressed through the available political procedures should govern, and any limits on this exercise of popular power are unjustifiable. However, this principle competes with another equally important principle. This holds that the majority cannot do whatever it likes in the name of democracy. There are certain outcomes that cannot be tolerated in a society that claims to be just, no matter how democratic the procedures that gave rise to them. For societies to be worthy of the label democratic, there must be a balance between procedural and substantive dimensions, which, being contingent and contextual, will change and vary over time. In order to operationalize this view of democracy as demanding more than majority rule, the Supreme Court recognized that popular sovereignty has to be supplemented and constrained by other constitutional principles. After acknowledging that it is a highly textured expression that lends itself to diverse interpretations, the Supreme Court confirms that the rule of law, along with federalism, is a basic requirement of any stable, predictable, and ordered society. Staying at the relative safety of high abstraction, the Supreme Court identified three major components to the rule of law: the existence of one constitution and set of rules for both government and private persons, the creation and maintenance of an actual order of positive laws that embodies the more general principle of normative order, and the insistence that the exercise of all public power, including that by the courts, must find its ultimate source in a legal rule. Accordingly, explicitly adopting a minimalist version of this constitutional axiom, it maintained that the rule of law principle requires that all governmental action must comply with the law, including the Constitution. For the Supreme Court, therefore, majority rule combines with other constitutional principles, such as the rule of law, to ensure that democracy is implemented and respected in a procedural as well as substantive way. The consent of the governed is a value that is basic to our understanding of a free and democratic society. Yet democracy in any real sense of the word cannot exist without the rule of law. It is the law that creates the framework within which the sovereign will is to be ascertained and implemented. To be accorded legitimacy, democratic institutions must rest, ultimately, on the legal foundation. That is, they must allow for the participation of, and accountability to, the people, through public institutions created under the Constitution. Equally, however, a system of government cannot survive through adherence to the law alone. A political system must also possess legitimacy, and in our political culture, that requires an interaction between the rule of law and the democratic principle. The system must be capable of reflecting the aspirations of the people. Constitutional government is necessarily predicated on the idea that the political representatives of the people of a province have the capacity and the power to commit the province to be bound into the future by the constitutional rules being adopted. These rules are binding not in the sense of frustrating the will of a majority of a province, but as defining the majority which must be consulted in order to alter the fundamental balances of political power, including the spheres of autonomy guaranteed by the principle of federalism, individual rights, and minority rights in our society. Of course, those constitutional rules are themselves amenable to amendment, but only through a process of negotiation which ensures that there is an opportunity for the constitutionally defined rights of all the parties to be respected and reconciled. In this way, our belief in democracy may be harmonized with our belief in constitutionalism. Constitutional Amendment of 10 requires some form of substantial consensus precisely because the content of the underlying principles of our Constitution demand it. By requiring broad support in the form of an enhanced majority to achieve constitutional change, the Constitution ensures that minority interests must be addressed before proposed changes which would affect them may be enacted. It might be objected, then, that constitutionalism is therefore incompatible with democratic government. This would be an erroneous view. Constitutionalism facilitates, indeed, makes possible, a democratic political system by creating an orderly framework within which people may make political decisions. Viewed correctly, constitutionalism and the rule of law are not in conflict with democracy. Rather, they are essential to it. Without that relationship, the political will upon which democratic decisions are taken would itself be undermined. So expressed, the Supreme Court is adamant that majority rule is not tantamount to democracy and does not take precedence over all other values and principles in the Canadian constitutional order. Any other argument profoundly misunderstands the meaning of popular sovereignty and the nature of a constitutional democracy. In reaching this understanding, the Supreme Court clearly assumes that such ideals are attainable in the sense that rules rule. Its approach is premised on the claim that rules can be stated and applied in a relatively determinate and uncontroversial way in the vast number of circumstances. This continued preoccupation with the need to ground an objective practice of judicial interpretation that obviates judicial value choice and that does not tread on the democratic toes of legislative decision-making is doomed to failure. The history of 20th century jurisprudential and constitutional theory has been dominated by almost countless attempts to provide an account of the court's role that is consistent with the democratic priority of majoritarianism. As judicial review involves unelected judges invalidating the actions of elected legislators, all judicial review is anti-majoritarian and, therefore, presumptively undemocratic. No theory can reconcile judicial review with majority rule. What is perhaps more important is that this continued search for the jurisprudential grail is unnecessary. Having abandoned the crude Becquelian counter-majoritarian challenge to the court's democratic legitimacy, the Supreme Court should follow through on the political logic of its own analysis. It must have the institutional courage of its own jurisprudential convictions. Once liberated from the confining strictures of traditional thinking, the question of how and whether courts act with democratic legitimacy is of a very different order and character. The Becquelian difficulty has little to say about what values are important to democracy other than an unthinking regard for majoritarian processes. Once the principle of democracy is accepted to have a substantive as well as formal dimension, the justification for judicial action must also be viewed in substantive as well as formal terms. The work of courts need not be judged by their capacity to be objective and impartial nor by their willingness to be consistent with and not interfere with majority politics. Instead, they can be evaluated in terms of the value choices that they make and the contribution that their decisions make to the promotion of democracy in the here and now. If the traditional assumptions, that legislatures are unprincipled and political and that courts are principled and reasoned, are dropped, it is possible to arrive at a very different understanding and account of the relation between courts and legislatures. For instance, the conclusion is possible that legislatures and courts are both principled and unprincipled to greater and lesser extents at different times and that each can further, as well as inhibit, the cause of democratic justice on a particular issue as well as the other. The more pressing conundrum, therefore, is this: if democratic procedures do not guarantee democratic outcomes and democratic outcomes need not result from democratic procedures, how can we best organize constitutional arrangements so that democracy as a whole is more, rather than less, likely to prevail? Accordingly, the appropriate inquiry in a constitutional democracy is not to ask whether the courts have acted politically and, therefore, improperly, but whether the political choices that they have made serve democracy. Moreover, in a democracy, what counts as being democratic is contingent and contextual. Because this is substantive and rhetorical, not formal and analytical, it will always be a contested and contestable issue. Law is politics. Nevertheless, what counts as a democratic decision is not entirely reducible to a political and, therefore, open-ended debate about what is most appropriately democratic at the time and under the circumstances. The formal dimension of democracy insists that some account is taken of the general institutional location and position of relative governmental agencies. The fact that legislators are elected and judges are unelected has some political salience. However, that a locational decision will itself be political. As the Supreme Court said, it was the court's own assessment of its proper role in the constitutional framework of our democratic form of government Like the general mix between the rule of law and its other constitutional components, the democratic demands of the rule of law will be context-specific. These defining principles function in symbiosis. No single principle can be defined in isolation from the others, nor does any one principle trump or exclude the operation of any other. Sometimes, it will play a minor role and sometimes it will play a much larger one. Of course, there is no meta-principle that is not itself political and controversial that can fix that role and balance. It is part of the continuing debate about democracy itself. For example, in societies such as Eastern Europe and Latin America that are in transition from repressive regimes to democratic governance, what is considered just and appropriate will depend on the contingent extent and intransigence of prior injustice. The rule of law may have a valuable role in facilitating that shift and, rather than grounding legal order, it serves to mediate the normative shift in justice that characterizes those extraordinary periods. Indeed, in certain circumstances of crisis and upheaval, the courts might be temporarily better placed to effect large or important changes in an effective manner. The task of determining what courts should and should not do is a work in progress of the most enduring and political kind. Conclusion. While it is understandable why most judges and jurists wish to present adjudication as a bounded and objective enterprise in which reasoned judgment can dissolve and resolve problems that have proved inhospitable to legislative resolution, it is a misplaced ambition, because there is no way to bring such a project to a satisfactory conclusion. Continuing attempts to do so merely exacerbate the problem of democratic legitimacy and erode the very confidence that the legal establishment is trying to maintain. A better response would be to acknowledge that adjudication in a society of diverse and conflicting politics is an inevitably ideological undertaking. Once this acknowledgement is made, courts will not necessarily become odious or surplus to democratic requirements. Instead, it might be accepted that both courts and legislatures are involved in the same game, namely delivering substantive answers to concrete problems. Furthermore, in doing that, neither courts nor legislatures have a lock on political judgment about what it is best to do. For example, although Souter in Glucksburg states that legislatures are the place to engage in fact-finding and experimentation, which should be out of the question in constitutional adjudication, he does concede that sometimes a court may be bound to act regardless of the institutional preferability of the political branches as forums for addressing constitutional claims. On the issue in hand in Glucksburg, Souter actually concluded that I do not decide for all time that respondents' claim should not be recognized. I acknowledge the legislative institutional competence as the better one to deal with that claim at this time. This seems right. The respective responsibilities of judges and legislators cannot be defined outside the never-ending debate about what democracy demands and by what is best served at any particular time. In both judicial and legislative decision-making, it is mistaken to allow theoretical principle to be the enemy of pragmatic good or to allow general institutional competence to be the enemy of specific substantive good. What courts and legislatures do, as well as how that work is divided, is a highly political matter whose resolution will inevitably be contingent, contextual, and contested. In what appeared to be a typically astute comment, the late Stanley De Smith stated that legal theorists have no option but to accommodate their concepts to the facts of political life. Even rudimentary survey of mainstream constitutional theorists suggests that De Smith was engaging in wishful thinking, judged by their persistent refusal to ensure that conceptual analysis retains some connection with political reality. Contemporary legal theorists have managed to keep their options wide open. Using Canada as my example, I have tried to demonstrate that constitutional law is a site for political conflict, not a structure for it, and that constitutionalism is an endlessly fluid process in which change is the only constant. In this regard, the wrangle between documentarians and doctrinalists is a faux debate. Each assumes that there is some solid and apolitical plane on which to stand when, in fact, there are only more or less slushy surfaces to navigate. Of course, this realization is only a problem for those who insist that the need for stable and dry ground is necessary for there to be a legitimate and functioning constitutional democracy. I am not one of those. Instead, I maintain that such an understanding is not fatal to the important project of constitutional democracy, but it demands that lawyers learn and hone a different set of skills and attitudes. When there is water all around, the best thing to do is to start swimming. Contrary to what the soapy Sams might believe and what the bulldogs might hope, trying to walk on water is a feat best left to others.